shareholders. So that term just is superfluous. So that's why I took that out. Investors, I agree with Ms. Pettit. I'm not sure exactly who all there might be as outside investors that aren't really involved in the day-to-day. And all I would say, because we do keep that pretty confidential, if Mr. Buchanan is going to go start talking to investors of the company that aren't involved in the day-to-day management, that's just a different level that I would hope we could talk about and work through before something like that happens.
Okay. So
I guess it's not the end of the world. Certainly Mr. Buchanan can come ask the court if he needs to talk to an investor. So
yeah, let's take investors out.
Okay, it's out. So part C, they're wanting to restrict when Mr. Buchanan can go to the office. I just think that's a little bit.
Take that out.
The only reason I raised it, and maybe it'd be helpful if I could explain the changes, is with COVID, there's not always someone in the office. We are happy for Mr. Buchanan to come whenever he wants. We just need coordination. That's all we're trying to make sure is with COVID, a lot of people are working from home. And so if he wants to come, we need coordination.
I assume though that he's going to get the keys to the office. That should be in here somewhere. So if he wants to go and hang out in the office, he has the right to do that. So I want him to have full access. So that needs.
I added that in on part C.
So yeah, if he wants to meet with somebody, he needs to give them notice. But if he wants access to the office, he should be able to go there anytime. What's next?
The next is part E, to retain accountants, attorneys, vendors. They've added as is necessary. I'm just afraid that's gonna.
That's fine. As is necessary is fine.
Okay. I wasn't sure why, maybe Ms. Shigaris can explain. I wasn't sure why we would need to strike section F that she wants to strike.
It really relates to what the parties agreed to put in down in paragraph 12 is right now where we are in the litigation, all parties have claims against each other. And we've agreed that Mr. Buchanan does not have any authorization or power with respect to any of the claims that are being asserted in the case against FSG or on behalf of FSG.
Mr. Buchanan, what's your thoughts about this one?
Your Honor, can you hear me okay?
Yes.
So, if we go down to paragraph 12, Ms. Shigaris, can you help me with that, or Ms. Pettit?
Oh, yes, I'm sorry. Let me scroll down.
Because they tie together. So here in paragraph 12, receivers not authorized or empowered to take any actions. It's an observation. I'm not arguing either side. I would note that this particular paragraph does not have the language we see above unless the court otherwise approves such. So it's difficult for me, and I would ask if that be put in there, that I've come to you if I decide that I think that the receivership should be expanded in connection with my report.
Yeah, I agree with you on 12. It should say without, it should, okay, let me go because I got to get through this. So go back to the previous paragraph.
Which ties into the ability to even be able to determine.
I think this is fine. F is fine. Go down to the next one. And then 12, I want to add the receiver is not authorized or empowered to take any action with respect to claims without court approval, wherever that needs to go in. Because it may turn out that he can bring claims, but at this point.
Yeah, I think our biggest concern, Your Honor, I just want to make sure I make this clear, is my client has claims against Julie's clients, against Mr. Reimer's clients. If what I hope is not being done here is that they're using this receivership for Mr. Buchanan to come in and then somehow dismiss our claims. I don't think that was the intent of what this receivership was to be, but that's our concern.
I think that, that's not a problem. So number 9.
Yeah, sorry, let me accept this change from Ms. Shigaris. This one I'm fine with. This was her change and I don't mind on that one. 9 and 10, I'm okay with it. When I tried to accept 9 and 10, it was making me also accept 11. So 9 and 10, I'm fine with. It was just weird on track changes for some reason. 11 is the one I don't really understand, and I'm just afraid of the extent that's limiting Mr. Buchanan's ability to do anything.
I actually thought this was more just trying to, currently the day-to-day, what we agreed was that Mr. Buchanan right now, before his initial report, would not change how the, management, employees, the operations, he's going to come in, look at the books and records, interview all the people that he deems are necessary and report back to the court. So currently FSG.
I would say instead of during the pendency of this receivership, I would say during, without further order of the court, the management and day-to-day operations, blah, blah, blah.
That works for us, Your Honor.
And I don't know about this agreement, but is this the current agreement?
Yeah, that's what I'm saying. These are voluminous documents, and my fear is that Mr. Buchanan does one thing, and that's going to send up, alarm bells of them telling Your Honor that that was in violation of the management agreement. I mean, what if we just say without further order from this court, the management and day-to-day operations of FSG shall
Continue.
Unchanged or something like that?
I'm fine with that. We were trying to be more specific, but as I'm fine with that.
Let me do this without track changes and make sure I haven't totally messed up 9, 10, or 11 without further. Okay. I think it looks right. So let me go back to markup. Okay.
We dealt with 12.
I think that's it. Let me double check. Yep, that's everything.
Great, guys. I got to get to the next one. Go ahead and
I
send
will
this.
send this to you and copy Ms. Shigaris right now, Your Honor.
Sorry, Your Honor, we actually had something else that we had said. I think this will be very quick, but as we talked about, that we do plan to file an interlocutory appeal. After the hearing, we looked at the rules of appellate procedure and a court of appeals case out of Austin from this year that looked at this very issue of a motion to stay in the appellate court on an interlocutory order of a receiver. And the first step before we can ask the Court of Appeals to stay it is to request that Your Honor issue a supersedious bond and determine that amount. I've circulated that order to Ms. Pettit, and I understand that she does not object to the bond amount being set at $10,000. And we submitted an order to your court, a proposed order to that effect.
Is that true, Ms. Pettit?
Yes, Your Honor.
Go ahead and email that in the same email. If you both agree, just say that both orders are agreed to as the form, and then email those to me. I assume none of the other attorneys have any objections to what's being done right now.
No, Your Honor.
Okay.
Judge Hoffman,
Right,
I know, just real quick, I know you're in a rush, but there's another somewhat important lingering issue in that we haven't entered a order consolidating these cases yet, particularly if Ms. Shigaris is planning to take an interlocutory appeal of this receivership. Could get messy. We had a disagreement on the form of the order regarding how Your Honor wanted to handle the Delgado matter.
I was fine, Ben. Once you submitted that and I saw the other comments from counsel, I don't intend to submit a competing order.
So
Okay,
have I signed it or not?
No, and based on what Ms. Shigaris just said, you have an agreed order.
So go ahead and email that to me as well. So all in the same email, include all 3 of those orders. And I'll go ahead and sign all 3 of them.
Great.
Thank you.
Okay.
Thank you, Your Honor.
Thank you, guys. You have a great day.
You as well, Judge. Thank you.
All right, I am way behind. Okay. Moss v. Principe. All right, everyone here for that?
Yes, Your Honor.
Morning, Your Honor. Yes, sir.
Okay. We're here on a motion to seal. Is that correct?
Yes, Your Honor.
Okay. Tony, let's go on the record on cause number DC 209893, Moss v. Principe. Counsel, make your appearances.
Dan Wide for the judgment creditors and plaintiffs.
Hunter A. Nunn, NUNN, Warrant Nunn, also here for the plaintiff's judgment creditors.
Where's your opposing counsel? Are they here?
I do not see them, Your Honor.
I thought he was on.
That's strange. Okay. Maybe they just don't oppose it. Mr. Prince, I thought I saw Mr. Princip here. Is he
I
here?
saw Miss Otta too.
Is he not on?
Philip, whatever, Simpkins, whatever his name
Is anyone else here on the Moss case?
is. Brandon's here.
I don't see him, and we'll go ahead and sign this, and if they have an issue, I guess they can file a reconsideration. Let me go ahead and pull it up.
There you go.
Did you submit an order already?
Yes, Your Honor. An order was submitted without attempting to snatch defeat from the jaws of victory. I wanted to run the court just through my exhibits. The order is twofold to some extent, and the motion is twofold in and of itself. We're seeking a temporary order sealing first under 76A, a temporary order, wherein the court then would schedule a hearing at least 14 days later for the full order, unless the court just wants to grant the full order off the bat.
No, I'd rather do it.
Okay.
I want to follow 76A, so.
Yeah.
I
And
don't want to do it that way.
Right,
I don't
and
see that you did
and I
not,
think-
I don't think you submitted an order on this. It's not on the system.
I apologize. We had one thing kicked back, and that could be it, but I can have that to you this morning.
Go ahead and e-file it and email my court coordinator.
Yes, sir. What I was going to suggest to the court is this motion dovetails into some others that are probably going to come before the court. So with our few minutes that you have allotted to us, I wanted to run you through my exhibits just briefly and explain to you that, one, we're seeking to seal notices of subpoenas and subpoena ducis tecums, and we're seeking to seal post-judgment discovery to non-parties. Simply third parties, non-parties. If I file a notice of subpoena to go after X bank, in the age of electronic banking, once the other side, or not the lawyers, but the parties see that,
Go ahead.
they can open and close bank accounts and move money and assets quicker than you and I can draft motions and get hearings and so on and so forth.
So let me ask a question. So are you asking to seal the entire file or particular documents or particular types of documents?
Just a specific type of document to non-parties.
I'm not sure the clerk's office is going to be able to do that. I've never done a sealing order, so I'm going to get my clerk here to see if they can do that, because usually it's either you seal the entire file or particular designated files.
I've been in your
Ashley,
situation.
Are you able to see? Can you cast the form?
I've been told by a clerk before that when I was on the bench briefly that, I'm sorry, you can't do that. And I said, I'm sorry, why not? And they said, our computer system's not designed to do that. And I said, okay, I understand. I'm
bringing my clerk in to find out if we can do that.
Okay.
I kind of think my concern is that it would require the clerks to look at every single document and try to make that type of determination. And I'm concerned that would be difficult. Let me just ask her how she wants to deal with that.
Oh.
She's on her way right now.
Because the court allotted about 15 minutes, I hope you don't mind that I'm a little bit wound up, because I wanted to just disgorge all my argument to you and be done with it as quickly as possible.
Go ahead.
Okay. So, Judge, obviously under 621A of the Texas Rules of Civil Procedure, post-judgment discovery is conducted in accordance just like with pre-judgment discovery. That dovetails into 76A of the Texas Rules of Civil Procedure. 31002 of the Civil Practice and Remedies Code. We're entitled to the aid of the court, and I think you're going to become nauseous or sick of hearing that term, but only when, if you will, as the court knows, only when,
Mr. White, let me stop you for a second. So I have the lead clerk who's been assigned to the 68th District Court here, Rose De La Cerda. And I wanted to talk to her about what's kind of going on. So while she's here, so she just showed up. And Tony, are you able, you may have to speak up, Rose, when we ask questions. So, maybe you could sit over here so that, and speak into the microphone, because I want Tony to be able to hear. And Tony, let me know if you can't hear. So there's a request to seal documents in a way that I've not seen before. So usually when we seal documents, there's like a sealing order and it seals the entire file, or it seals particular documents. And so, we haven't had a problem with that. What they want to do in this case, which I'm concerned may be problematic, is that they want to seal a type of document. So anything that is related to obtaining discovery from a third party, I'm just wondering how you would make that determination if we did that. Is this something, I don't want to make an order that's going to probably be very difficult for you to follow. Does that make? Yeah, so basically, anytime a document, as I understand it, comes in, you would have to you'd have to know that this file says that you would have to make a determination if this should be sealed or not. And I'm concerned about that for your sake and for my sake, that could be hard to do, because I mean, we have over 1,300 active cases at this point, and to try to make that determination with each filing, I'm concerned about. Right. She said that would be, were you able to hear,
No,
Tony?
I ask you to
Okay,
stop.
you got to speak up. You speak in the microphone. So if I understand it, Rose, you said that it would be problematic to do it that way, to do a sealing order that way. So either we seal the entire file or we seal individual documents that are told to you. Okay, and she agreed with that. Were we able to hear that, Tony?
not too much, Judge, but I think it's being made maybe a little bit more complicated than necessary, because we can label which, these are just subpoenas, notices of subpoenas and subpoenas, and any applications for writs of property attachment, garnishment, levy. My comment to you, Judge, is that it's very narrow, because public policy obviously is against sealing, but we can either have documents hand delivered as if we were pro se, or mailed to the clerk's office, or emailed. I mean, it can't be simply all or nothing, if you will. But
It's not all or nothing, but the way this has always worked, at least that I've seen, is that you say, okay, these 5 documents need to be sealed, or these 6 documents need to be sealed. It's not like these particular type of documents in the future need to be sealed.
Well, we can address it that way and go through the file and say, these are the ones that we'd like to have sealed. And they're all going to be notices of subpoenas, and that's pretty much it right now.
That have already been filed.
Yes, but we want to, in the future, we keep finding bank accounts and trust accounts and things like this. And when we send notice of subpoena and subpoena duces tecum to the third parties, the other side, clients can close these accounts. We're dealing with very sophisticated, technologically savvy individual on the other side who.
I get all that. I don't have any problem with sealing it. it's the way you want to do it is the problem. And so you don't have to convince me to do it. I just need to, how do we do it?
Yes,
if you list out these 10 documents need to be sealed that have already been sealed, that's fine. What if they include something? I think how to do this. What's the easiest way to do this for you?
I don't know, because like you said, you can say to bring them, maybe, and maybe they can let us know that it's supposed to be.
We're happy to work with them any way you want us to.
Okay, so what we'll do, is include in the order and the particular documents that have already been filed that need to be sealed. Go ahead and include those so that she
Yes.
can know which ones she needs to seal. And then for future documents, go ahead and include that you will, I guess, that an order will be attached and be provided via hand delivery to the lead clerk of the 68 District Court.
Okay.
So that she knows will be hand delivered and not e-filed, those documents so that, so it'll have the, so you need to, just so it's clear, you need to have the order with the documents. So whatever order I sign needs to be with the documents and then hand delivered to her and say, this needs to be sealed. So it doesn't somehow get, because if you e-file it, it could go to any clerk.
Right.
So I don't know if they were doing e-files when you were a judge, but with e-filing, this could be processed by anybody. And so she needs to be able to see it and needs to be able to know, okay, this needs to be sealed.
Yes, sir.
So just give me just modify the order and get that to me and we will get it signed. Go ahead and email my court coordinator and my, and e-file it, okay?
Yes, sir. The other aspect of my order, besides attempting to seal discovery to non-parties, if you will, was that the court be allowed to seal any disparaging comments that were made about any of the counsel or the attorneys. Hence, the comment that showed up on YouTube that you brought up earlier in the week, I believe. And I was just trying to provide you something that says, hey, we're not going to let that stay out there for the public to view, if you will, if it's
That's not part of the clerk. It's not part of the clerk's record. That was never. So, but I guess you could say if there's, what you could include in here is any filings that include that post will be sued, will be sealed.
Right.
So if for example, because I said, hey, if you want to file additional motions or whatever,
right,
that would, anything that is.
Yes, sir. So I beg your attention for just a few more minutes, if you will, and wanted to ask you if it's possible, if you could just simply look at the few exhibits that were attached, and specifically one or two, because what we're dealing with here is threats of coercion by one of the judgment debtors towards Ms. Barmore, who's also a defendant but has not been served. And these are text messages offering to pay for her legal fees by one of the judgment debtors. They are also documents admitting to discovery that may be in the possession of of the judgment debtor's co-counsel. Exhibit B, if you will, that you had says that Mr. Martin admits that his lawyer has actual evidence on the Swiss bank account in Ms. Barmore's alleged name. Well, we never been provided that by those lawyers. So either Mr. Martin is lying.
Is this part of the motion to seal or is this something else?
No, it was part these were my exhibits and they were part of the motion to seal. But
Okay,
this is why.
So I have other hearings I got to get to. Is there any relief that I haven't granted that you've already asked for?
Not yet.
Okay. All right. Good to see you guys.
Judge, I would like to ask one question if I can, please, very quickly.
Okay.
I did notice that we also have a setting at 10:45 on this case, and
I don't know why. Why do we have two settings?
That's a good question, Your Honor. I wasn't clear about it, and I just wanted to ask the court if there's anything that the court would like to discuss at that time, or
I think it was a continuation of a previous hearing. If you guys don't need it, I don't need it. You might just want to talk to the other side, and if you guys want to cancel, that's fine.
Yes, sir.
I thought, Judge, it was because you enjoyed my company so much that you just. That's it, Judge. I'm done. Thank you.
Good to see you guys.
Thank you. Have a great
Your Honor.
weekend.
Have a
Your Honor.
great weekend.
Thank you, everybody on the staff. I mean, the reporter, coordinators. Thank everybody. Have a safe weekend.
Thank you. Hernandez v. Progressive County Mutual Insurance Company. Motion to transfer venue.
Yes, Your Honor. Sheree Batzel here for Progressive.
Jim Walker here for the plaintiff.
All right, let's go on the record on cause number DC 204386, Hernandez versus Progressive County Mutual. Counsel, make your appearance.
It's Jim Walker for the plaintiff.
Sheree Batzel for the defendant.
Let's proceed. It's your motion, Ms. Batzel.
Thank you, Your Honor. Your Honor, this accident happened in Denton County. Progressive is a corporation, obviously not a person. The plaintiff is a resident of Collin County. There is no venue provision.
Plaintiff or the defendant is the resident of Collin County? I thought it was the defendant.
Well, I said defendant's a corporation. I mean, they have a facility in Collin County, but plaintiff is also a resident of Collin County. And so under either the insurance code venue statute or under 15002, venue would be proper in one of those two counties and those two counties only. There is absolutely no basis for venue in Dallas County because the accident happened in Denton County and nobody resides in Dallas. There's nothing in Dallas. And so venue would only be proper in Collin or Denton County. Because
And as I understood from reading the briefing, Mr. Walker, you were saying under principles of convenience and form non-convenes that I should transfer it to Dallas, correct?
Either keep it in Dallas, it's already in Dallas, keep it in Dallas under those principles, or
Yeah, keep it in Dallas, I'm sorry, yeah.
or if the court does determine to transfer it, then to send it to Collin, since as Ms. Batzel just mentioned, Collin County is where these parties are residing, and it would be more convenient there.
And I would point out two things, Your Honor. The only convenience statute that allows for transfer of venue is in 15002, and that allows upon motion of a defendant. It does not allow upon motion of a plaintiff because.
Well, and it also has to be in a county of proper venue anyway.
Correct. It had to have been in a county of proper venue.
And Dallas County doesn't appear to be a county of proper venue. So
correct.
What is your position about transferring it to Collin?
My position is we want it transferred to Denton where the accident happened. There is case law that states if plaintiff fails to file in a proper venue, then defendant gets to choose if there are multiple counties of proper venue. And there's a Dallas Court of Appeals case on that. There's the Supreme Court case on that.
I think you're right on this one. So I will go ahead and grant the motion to transfer it to Denton. But I don't see that you filed an order.
I filed an order this morning, Your Honor.
Okay. Can you email that? Can you email that to my court coordinator just so she can get it?
And there are a couple of things in that proposed order that filed. It says pursuant to the agreement below in the order. There's no agreement to this proposed order, so I think
I'll edit it. Initially, we had an agreement, but he objected to having to pay the fee to transfer to a court of proper venue. So we had to set it for a hearing.
And since we're talking about, I'm still talking, Ms. Batzel, if you would give me a chance to finish. Since we're talking about since she's going to her county of proper venue, as she calls it, then I would ask that that her client pay the fee as she requested the county.
Your Honor, it's his obligation to file in a county of proper venue. It's not our obligation to have to pay to move it to a court of proper venue or county.
Unfortunately, Mr. Walker, I mean, you picked a county that wasn't a county of proper venue. And so I think she's unfortunately right about that too.
Yeah, it was a city of Dallas. It was the city of Dallas. And based on the city of Dallas,
I once had a case in Judge Greenberg's court when I was in private practice where the accident happened in the city of Dallas. The accident started in Dallas County, but finished in Collin County. And so we had a big fight about, well, where did where the collision occurred or where did the cars ended up? And I mean, that happens. No one is fussing with you, Mr. Walker. These things happen.
Oh, no. Well, one person is fussing with me, and I really didn't think it's necessary, to be honest with you. But we'll go with what the court said.
And I object that it be said I'm fussing because I want a court.
No one is criticizing you, Ms. Batzel. You're right.
No.
All right, guys, just get me in order, Ms. Batzel. It'd be great if you could get to me. It doesn't matter. I'll be here for a few more hours and then I'll be back either on Monday or Tuesday. So if you want me to sign it today, I need to get it before 1.
I'll make that one change to it and then I'll send it right over.
All right, thank you, Ms. Batzel.
Thank you, Your
Mr.
Honor.
Walker.
May we be excused?
You're welcome.
Yes.
Good to see you
Guys,
again,
have a
Judge.
great day.
Thank you, you too.
Okay, Hambrick versus Luminant. Both
Morning, Your
sides
Honor.
here.
Kevin Queenan on behalf of Mr. Hambrick.
Walt Herring's here on behalf of Luminant, Your Honor.
All right, let's go on the record on cause number 207704, Hambrick versus Luminant Mining Company. Counsel, make your appearances.
Walt Herring on behalf of the defendant Luminant.
Kevin Queenan, Your Honor, on behalf of the plaintiff, Mr. Hambrick.
All right, you may proceed.
Thank you, Your Honor. It's our motion, so I go first, I guess. The factual background, just very briefly, Luminant contracted they have a coal mine that down in Central Texas. They contracted with a company called Warfab to replace a cable. It's one of those big drag lines, you know, those huge drag line things, to replace a cable on the drag line. Hambrick was Warfab's employee, one of the guys who was working to replace this cable. There was a third company, Joyce Crane, was operating the crane that was lowering this cable. The crane, strap on the crane broke, the cable fell and hit the plaintiff, Hambrick. He alleges serious and life-threatening personal injuries as a result of this. We believe he's made a workers' comp claim with Warfab, but he has sued Luminant, the owner of the mine who contracted with Warfab to replace the cable. We sued Luminant for negligence and premises liability claims. When the suit was filed in June of 2020, we as the defendants sent a request for disclosures, interrogatories, and request for production to the plaintiff. What we got in return was a request for disclosure with a list of Exhibit B that had his healthcare providers. And in response to interrogatories, he noted that he had injuries to his leg, back, hip, shoulder, neck, and spine, so pretty much everything. And on exhibit, in response to the interrogatories, he also noted that Exhibit B of the disclosures were the only providers he has seen since October of 2009, and those providers only treated him for injuries from this incident. So basically, he told us Exhibit B of my disclosures are all my healthcare providers. Those are the only providers I've ever seen since 2009, and I only saw those providers for the injuries from this incident. So, not surprisingly, we then subpoenaed all those healthcare providers for their records. There weren't that many, I forget, 6 or 7 of them. Plaintiff then moved to quash those subpoenas. When we got the motions to quash, we inquired as to why they are quashing the subpoenas for these healthcare records that seem to be pretty relevant. They proposed, at that time, the plaintiff proposed a compromise that they would get the records, they would redact them as they think there might be some irrelevant information in there. Then they'd give us those redacted records. In response, I said, well, I don't know what's relevant or not right now. Who knows? He's got a back injury. So there could be a lot of things relevant here. Why don't we use we entered into agreed protective order. Why don't we just, if you're worried about confidentiality, why don't we just go on, you can label all these confidential. No one will know about it but us. And we can fight about whether these are admissible later, but they certainly are discoverable.
So let me ask a question. I want to make sure I kind of understand what the dispute is here. Are these medical records you're trying to get that are related to the accident, or these pre-existing medical records?
These are records that relate to the accident according to the sworn interrogatory responses of the plaintiff. They are the providers who he saw resulting from this accident. And he says they're the only providers he has saw since 2009. And they only saw them for this accident.
Is that accurate, Mr. Queenan?
Not 100%, Judge. There's two sides to the coin, no matter how thin it is. I can't find the word only in any of my responses. The issue is they issued subpoenas that are unlimited in time and are asking for 50 years of medical records. I said, hey, let's limit it to the date of the accident forward. That was not good enough. I didn't suggest that I gather the records myself. What I suggested, it works. It's never not worked, Judge. I mean, not everyone agrees to it, but it's never not worked, is let their record service get the records. Their record service can Bates number the documents sequentially, send me the records and give me 15 days to look at them. If there's something in there that I think is inappropriate or not related, I will redact it. I'll give them a privilege log. If they want to test my privilege log, we'll send those records to you, because the problem is the case law says they're only entitled to medical records that relate to the body parts that are injured. And it's virtually impossible to send a subpoena to a medical provider and say, you know, don't give me the gynecological or the urological records, but give me the back records and the arm records. And so the easiest way to sort that out is to let us look at the records. And if it's something that's unrelated, we will then let that be tested out. You can't unring the bell. I mean, it's a little harder to make.
So, Mr. Quinn, and I've dealt with this issue, as you can guess, a million times, and
Sure.
I try to be as consistent as possible on all these. So I just wanted to make sure I understood what was going on. So
Right.
for any records that are related, so I assume there's some providers that he had only seen after the accident, right? These are not like a family physician he may have seen before and after the accident, but for any medical
that's not-
providers.
That isn't what he said in his interrogatory, Your Honor. He says, I have not received
let me just
healthcare treatment.
Mr. Herring, let me just finish. Let me
That's-
just finish, okay?
Okay, sorry.
It's okay. So for any medical providers that you're claiming reimbursement for in this case that he did not see before the accident, he can get those records. He doesn't need to provide them to you. Those are, you know, there may be stuff in there that need to be redacted, but he needs to give those. He can get those without any type of restriction. For pre-existing
From the day of the
records,
accident forward. Yeah.
from the day of the accident forward. For any pre-existing, what I allow in basically every case is 5 years worth of treatment prior to the accident related to the same body parts that are being claimed. So if it's a back injury, then back treatment. If it's a neck injury, then neck treatment. But if it's gynecological treatment, that's not, and there's no claim for gynecological, well, this is a guy, so I don't think they'll be gynecological, but whatever, he got Viagra or something like that, that's not going to be related. And that's not to be something that you can get. And so for pre-existing records, then you can go through this process you're talking about, make whatever claims you want to, and review them. And then if there needs to be a fight, then I'll make that ruling. So does that make sense?
It does, Your Honor. But our motion goes a little further than that too. We're
Okay.
asking for some other things as well.
The workers' comp records as well.
I'm sorry?
The workers' comp records as well.
Well, the workers' comp records, yes. His income tax records as well. But even still on the healthcare records, his answers to the interrogatories are clearly incomplete and inaccurate. They're demonstrably false. For instance, he says that he's only been treated for these since 2009, 10 years ago, for the people on Exhibit B. They did produce records to us in compliance with their belief of what they had to do. They just gave us redacted records. But even those redacted records indicate that there are other healthcare providers who he did not disclose. For instance, he received pain medication in 2015 and 2018, prescription pain medication. He did not disclose those. He's clearly got something going on. We think it's with his back, which he's claiming injuries for. In addition, the records they did produce indicate that he saw an orthopedic surgeon for his broken ankle, which is what he suffered in this incident, that he did not disclose on Exhibit B. So we're entitled, he needs to amend his interrogatory responses and providers and give us a complete provider list. It's clearly inaccurate.
You need to give them a complete provide. I don't know if that's true or not, but if you need to provide them any providers that are as a result of this accident, any providers that treated him in the 5 years prior to the accident, and then to the same areas of the body, and any post-accident to the same area of body as well. So any providers, you need to provide all of those. For the workers' comp records, you need to provide, give him an authorization to get the workers' comp records from this file. For any other worker, say he has 3 workers' comp injuries and there's 3 different files on them, then for the other files, it can go through the process you talked about, Mr. Queenan, so you can make a determination as was there any discussion of any treatment that occurred in the 5 years prior to the accident up until today to the same areas of the body, then you'd have to produce those. But for other workers' comp injuries, it could go through the process you talked about, Mr. Queenan. Anything, and then for the employment records, or you wanted tax returns, is that what you said?
Yes, Your Honor. He's making wage claims, and he gave us the first 2 pages of his tax returns, but redacted. We can't tell.
So you're going to be required to produce any W-9s or 1099s to show income, but any type of investments he has or things like that would not be discoverable. And usually I do the 2 years prior to the accident and then after the accident.
Well, we gave them 4 years, so.
Okay, well then 4 years, you gave him more than I usually require.
But
Anything
they
else?
were redacted. We can't tell what's investment income versus what's actually our wages. It's just.
Well, if he gives you the 1099s and the W-9s, that should do it, right?
That should be very helpful, yes.
Okay, anything else?
No, Your Honor.
I believe that's it, Your Honor.
Mr. Herring, prepare an order on this, just run it by Mr. Queenan, and then you just get it to me, preferably by, let me just see. By Monday.
Yes, sir. One issue I have
Mm-hmm.
to bring up to the court. There's some depositions that are scheduled next week, Tuesday and Thursday in this case.
Mm-hmm.
They're of Warfab and Joyce Crane employees. My wife yesterday afternoon or yesterday morning found out she was diagnosed with COVID. She had a positive test.
Sorry to hear
So I
that.
have tested for it. I am negative as of yesterday afternoon, but those are 83% accurate, I think. So there's a chance that I'm going to try to quarantine. The depositions weren't noticed for Zoom. I don't know. I've asked Mr. Quinnan if he would continue those depositions, and I have not.
These need to be via Zoom. So
Yeah, that's fine, Judge. I mean, the request came in yesterday. I just hadn't got to it. We can do them Zoom, no problem. I mean, I'm going to go in person, but we'll allow Zoom.
Okay.
I just hadn't got to you. Sorry.
All right, Kevin. Just wanted to bring it up for now. Thank you.
anytime that somebody wants to attend a deposition via Zoom or any other type of remote, I'm just saying Zoom because most people use Zoom, but any other type of remote system like Zoom is going to be permissible.
Okay.
Certainly.
Thank you, Your Honor.
All right, guys, you be safe out there, okay? And good luck, Mr. Herring. With I hope your wife's okay.
I think she'll be fine. Thank you, Your Honor.
Thank you.
Thanks, Judge.
Are both sides here on Weaver versus KW Vision Properties?
Mark Tarabi is here on behalf of the plaintiff, or the movement, KW New Vision.
I see Mr. Mims here, I believe. Is anyone here representing Mr. Weaver or Miss Weaver? And Mr. Mims is right there. Okay, sorry. You need to unmute. You need to unmute Mr. Mims.
Okay, that better?
Yeah, that's better.
Okay.
Great. Okay, Tony, let's go on the record on cause number 201712. Council, make your appearances.
I'm getting some feedback.
Okay, go ahead and make your appearance.
Mark Tarabi on behalf of KW New Vision.
Myron Mims on behalf of plaintiff Deborah Weaver.
Let's proceed.
Yes, Your Honor. We filed this motion. We had personally served 2 non-party witnesses. And I guess if Your Honor prefers, I can do them separately since they're two separate motions, but I guess the summary is the same for both. But we personally served both Mitchell Cyrus and Shay Taylor personally with subpoenas for to appear at for non-party depositions in this matter. Mr. Mims and I and the court reporters were all present and appeared, and neither of the two witnesses appeared as scheduled per the subpoenas. We filed these motions seeking orders for contempt. It's simply trying to get the two non-party witnesses to appear and give deposition testimony in this matter. And since having served them with since having gotten served with notices of this proceeding, Your Honor, I've been contacted separately first by the daughter of Mr. Mitchell. And I don't know, is Mr. Mitchell, I don't know if Mr. Mitchell's present, but his daughter, Letitia. And then I was also contacted by Shay Taylor directly, and both have provided me with their agreement to appear for depositions in next Friday. And Mr. Mitchell's to be started at 9:30 a.m. and Miss Taylor's to be at 1 p.m. So, I think that what we'd really just be asking for the court to do at this point would be just to enter the orders for contempt by agreement, subject to their appearance as they've agreed at 9:30 and 1 p.m. respectively on the 30th of this month. And subject to, I guess, potential order for sanctions if they fail to do so.
So do we have on the line, I see there's two other people here. Who else do we have on the line? It's one that says Letitia O'Neill. That doesn't look like Letitia. Could you state your name?
My name is Mitchell Cyrus.
Okay. And could you spell your name for the court reporter?
My name is Mitchell. The last name, that's the first name. The last name is Cyrus, Cyrus.
And then we have somebody else here as well. Who is that?
Are you talking about me?
Yes.
My name is actually Conchata. Che is my nickname.
Can you spell your name, your legal name?
Conshetta. And my last name is Clayton, Clayton/Taylor.
And are you one of the witnesses that needs to be deposed?
Yes, sir.
Okay. And so you guys understand, I guess, that there's, and this is going to be via Zoom, or how are you guys doing this?
I believe, I'm not certain as to Mr. Cyrus, but Ms. Taylor has requested by Zoom, and that's fine.
If anybody wants to do this by Zoom, we can see how this pandemic keeps spreading. And so if you need to attend via Zoom, go ahead and you can attend via Zoom. I know that Mr. Cyrus, is he the gentleman that's of high risk?
Yes.
Yes.
Yeah, then I definitely want him to attend remotely if he can.
I think, Your Honor, the only reason I think that there was a question was his daughter had mentioned something to me about the technology concerns with the appearance by Zoom, but I'm fine with Zoom. That's not a problem.
Mr. Cyrus, is your daughter there or somebody there with you?
Yes, my daughter's here.
Can you have her say hello as well?
Hello. I was just asking him, does he want to participate via Zoom or does he want to participate face to face? And that's what I'm asking him now.
What does he prefer?
I would rather go face to face.
Okay. Are you sure? Because okay. If you prefer to be face to face, that's okay.
So it would be either you go to the office or you would do something just like this, on the computer where you talk to them through the computer.
Well, I can talk to them through the computer.
You can?
Yes, I can.
Computer. Okay.
Okay.
Yes, sir.
Thank you all.
And I'm sorry, I didn't catch your name, ma'am. What is your name?
Letitia O'Neill.
Okay, okay, you're the name on here. Okay, sorry.
Yeah,
Are you gonna, can you be there that day to make sure that he gets everything connected okay?
Yes, I can.
Thank you so much. We really appreciate it. We want him to be safe, so we
Yes.
prefer him to not have to come in for a deposition if possible.
Okay, thank you all.
Thank you.
Okay, thank you. All right, Mr. Tarabi, if you want to go ahead and get me an order on that. Mr. Mims, did you want to say anything? I didn't want to kind of cut you off.
I did, Your Honor. I did speak and agree with Mr. Tarabi about the 9 a.m. deposition. I did not see, or I'm not sure if I received. Can you hear me?
Barely.
What about now?
That's better.
Okay. I said I did agree to the 9 a.m. deposition, and I received that from Mr. Tarabi. I did not see or receive the 1 p.m. or 2 deposition. My concern is, as I expressed to Mr. Tarabi's assistant, I believe email, I have a standing 3 o'clock board appointment that has been long scheduled for that day. And I want to work with Mr. Tarabi as much as I can to try to get these done. We can even begin the 1 o'clock, but I'm going to have to step away and unfortunately, like, I'm on the agenda for this board meeting. So, and it,
Mr. Tarabi, do you need that much time? Do you need a whole afternoon for this? Or could you do like start 1 at 9 and 1 at 11?
If Ms. Taylor is available at 11, well, I mean, I don't anticipate it, Your Honor. I mean, you know, I just hate, I suppose if we could get Ms. Taylor's, if she's available to appear at 11.
Ms. Taylor, are you available at 11 that day?
I need to check my client schedule. Can you hold on 1 second?
Sure, go ahead.
Mark, the dates that I gave you that I knew I was available were next Tuesday and Thursday. Can you not do either of those days for her?
I think the date that was the date that she had said was working. My understanding, Myron, I didn't realize, I thought you said you were available until 3. So I didn't realize it was a conflict. I apologize.
Well, yeah, that's okay. I am available until 3. At 3 o'clock, I have a board meeting that starts at 3 o'clock.
Okay.
Or can you get the deposition done in 2 hours, Mr. Tarabi?
That's what I would anticipate at this point. Yes. I mean, I don't know that, I don't expect it to be that longer than 2 hours.
Yeah, I don't anticipate it either, but in the event, and I don't know what questions that may come up that we may have, but in the event, hopefully we can agree to continue it, even for later that day or the next day, or, so like I said, I'm
It's a lot easier to do that via Zoom because you can just sign off and then sign back on. You don't have to go back to the same location.
Yeah.
So, ma'am, does that time work for you?
Well, I think if Mark's saying, and I really can't imagine she's going outside of 2 hours, but if we can agree to wrap her up, in 2 hours from 1 to 3, or continue it, then I don't even think we need to move it.
Okay. Let's just keep it at that time then. Ma'am, can you get back on the phone?
We probably need more time for Mr. Cyrus than trying to.
Okay, sorry about that. I had to find my schedule.
We're just going to keep it for 1 o'clock. You don't need to move anything.
Oh, okay. Yes, sir.
So there is a possibility that if it takes more than 2 hours, that Mr. Mims has a 3 o'clock. How long is your?
It's going to run a better part of an hour and a half, maybe 2.
So they may have to take a break at 3, but hopefully they're going to finish you before 3. So just, you were great being on time today. Just make sure you're on time and hopefully they can finish up with you between 1 and 3.
Yes, sir.
Okay. All right. Any other questions?
No.
Do you have an order for me, Mr. Tarabi, that I need to sign?
Your Honor, we did submit proposed orders for both at the time of the filing, but I can submit with the date and time written in. I can get
That'd be great. Go ahead and get me an order. Go ahead and e-file and then email my court coordinator.
Okay, great. Thank you, Judge.
Thank you. And hey, Rhonda, I just sent you a couple. I just printed something out and I sent you an email that with some attachments that need to be printed out. Perfect. Anything else, guys?
That would be.
Excuse me, this is Letitia. I'm just wondering, when should I expect to see the Zoom link for next Friday?
Tarabi?
Yes, the court reporting service will get that to you. Typically, our service gets that to you the day before.
Okay.
I'll make sure they get that to you at least 24 hours in advance.
Okay, thank you all.
Thank you, Miss O'Neill. Thank you, everybody. All right, you guys be safe out there, okay?
Thank you, you too.
Thank you.
Bye.